Good morning, everybody, and welcome again to another webinar brought to you by the Hunter Business Chamber. Thank you very much for joining us. This one has particularly drawn strong interest as we look to unpack the recent WorkPac decision in relation to casual workers. So we'll get to the formalities of that very, very shortly. I'm Bob Hawes, the CEO of the Hunter Business Chamber. Today I'm joined by Amy Delore, our Policy and Public Affairs Manager, who will be helping to facilitate the event today. Also a special welcome to Kyle Scott. Kyle is the Associate Director of Australian Business Lawyers and Advisors here in Newcastle, and I'm sure known to many of you, and has already helped us in previous webinars on matters relating to worker issues. So thanks very much for joining us, Kyle. Before I start, I would just once again like to acknowledge that the Hunter Business Chamber operates across the traditional lands of the Awabaka and Worimi people. I'd like to pay respects to elders past, present and emerging, and also extend a warm welcome to any Indigenous people joining us today, and also remind everybody that we are in the midst of Reconciliation Week, and whilst mass gatherings aren't going to be the norm this year, we do encourage people to seek and get involved through online events. And to that end, go to the Reconciliation Week website and you'll find there's a lot happening, not only around here locally, but right across the Hunter. So as I said, our brains trust today is Kyle Scott, Associate Director with ABLA, and this has no doubt over the last week or so caused a lot of stir and a lot of activity. Kyle is a specialist employment and industrial relations lawyer and heads up the team at ABLA's Newcastle office. Thanks for joining us today, Kyle. This issue has obviously resonated with a lot of our members. We've got well over 200 registrations for today's event, and I'm sure there's many more business owners and operators out there who are feeling anxious about the decision and probably not being able to join us today. But I'm sure as time goes by, information will be disseminated about what this decision means. So just a quick outline of the procedure of the event today. As I said, Amy will shortly facilitate the discussion with Kyle and the presentation. And Kyle will spend the first part of the webinar providing an overview of the WorkPac versus Rosado decision. And then we're going to move to some questions. And we have had quite a few questions lobbed into us prior to the event, and we'll get through as many of those as we possibly can. Whilst you're muted today, if you do have questions or comments that come up through the course of the presentation, you're welcome to use the chat function, and we'll do what we can to incorporate those into the presentation as we go through. And if you would like to ask a question physically, make that obvious in the chat as well. I would also like to advise that the session today is being recorded, but we only record the speaker view, so you or your name will not appear on the recording or in any other record unless you happen to ask a question through the live. So please bear that in mind. Right, I'm now going to pass over to Amy and Kyle, and I think it's first up will be Kyle, who will be just going through a short summary and presentation about the decision. So welcome again, everybody, and welcome, Kyle, and thank you very much.
Thanks very much, Bob. Morning, everyone. So what I'm going to do now is I'll share my screen. I have a presentation slide to take you through. So, all right, so as Bob mentioned, it's obviously quite a significant development that we've seen last week in terms of the WorkPac and Rosado decision. So what I'll do is I'll spend the first part of the webinar taking you through that, unpacking a little bit of the background and recapping a little bit, and then explaining the Rosado decision and turning to the potential implications for businesses. And obviously it's a significant issue for businesses that do engage a lot of casuals and have a fairly casualised workforce, and particularly for those businesses that have casuals who are regular and systematic or have been employed for a decent period of time. So if we first just stop and consider what the legal issue is, it all starts with the Fair Work Act. The Fair Work Act's been in place since 2010. The national employment standards apply to all national system employees, and that's where you'll find the entitlements for annual leave, personal carers leave, notice of termination, redundancy pay, and a bunch of other things. Now, notably, some of those entitlements are expressed to not apply to casuals. So it says you will get annual leave unless you are a casual. as I was saying, the NES is where these entitlements are derived. The notable thing here is that the Fair Work Act and the NES, neither of them actually define what a casual employee is. So it says annual leave, there's annual leave entitlements, but you don't get it if you're a casual. But it doesn't define who's a casual. And that's really the critical legal issue here where this all starts. Contrast that with the modern awards system, where the modern awards, for the most part, do contain definitions of casuals. And for the most part, they define a casual as a person who is engaged and paid as such. And if you just think about that definition, if you engage someone as a casual, so you tell them that they're a casual and you pay them as a casual, then you would presumably meet that award definition and they are validly engaged as a casual. You would expect that there would be a degree of consistency between the way in which the modern award system defines who is a casual and the Fair Work Act and the NES. But as we found out in WorkPac and Scheme, which was the precursor to Rosado, that's not in fact the case. So if we turn to the first major WorkPac decision, and that was Scheme, 2018 Federal Court decision. Mr. Scheme was a casual fly-in, fly-out dump truck operator. He was a labour hire employee employed by WorkPac to perform work on particular mine sites for the labour hire company's clients. He was paid $50 an hour, flat rate. He worked 12-hour shifts on a 7-day rotating roster, so 7 on, 7 off. Because he was fly in, fly out, as you can imagine, there's a degree of planning around his rostering arrangement. And so his rosters, flights, and accommodation were effectively pre-programmed for 12 months in advance. So he had the flights booked, the accommodation ready for him when he arrived at the mine site. And so in this particular case, Mr. Scheme's employment came to an end and he approached the court and effectively claimed that he was not a casual. He was in fact a permanent and therefore entitled to a payment in respect of annual leave on termination. And they considered whether he was a casual for the purposes of both the NES and also the applicable enterprise agreement that applied to him. So the federal court and the full court of the federal court in Mr. Scheme's case effectively said, well, the question here is, what is the definition of casual in accordance with either that pre-reform enterprise agreement or more significantly, the National Employment Standards and the Fair Work Act? And as I said, the Fair Work Act does not define who is a casual. So they unpacked the case law authorities over the last 40 or 50 years, and the federal court said in the Scheme decision that you make that assessment by looking at the real substance, practical reality, and the true nature of the relationship, as opposed to merely what you call someone. And whilst the description given by the parties is relevant, it's not determinative. You have to look at the substance of the arrangement. They then said, and this was the critical part, the essence of casualness is that there's no firm advance commitment from the employer to a continuing and indefinite work according to an agreed pattern of work. So the absence of a firm advance commitment of work is the essence of casualness. They then said some of those indicia of casual employment referred to in the case law around unpredictability, irregularity, uncertainty, intermittency of work, they are just the usual manifestations of that fundamental feature, which is the absence of a firm advance commitment. So that was the court saying, this is the definition of casual employee under the Fair Work Act. So it has significance beyond simply Mr. Scheme. So that was around August 2018. The fallout from Scheme, as we've seen over the last couple of years, there was either a continuation or the commencement of quite a number of class actions. They were predominantly in the mining industry, but not confined to the mining industry, where the unions or the litigants in those class actions were effectively saying, well, here's another category of workers who are like Mr. Scheme or like Mr. Rosado. Now, WorkPac chose not to appeal the Scheme decision to the High Court. They could have sought to do that. They did not. Instead, what they did was they, in separate proceedings, the Rosado proceedings, they sought declaratory relief from the federal court. So they effectively asked the federal court to make a declaration that Mr. Rosado was a casual. So unlike Skene, Mr. Rosado was a casual and therefore not entitled to those leave entitlements. And in the alternative, if we can't satisfy you that Mr. Rosado was a casual, we want the court to make a declaration that we, WorkPac, are entitled to set off or recover the casual loading that was paid to him. So effectively, he should not be able to double dip. So that was WorkPac taking the initiative to seek those declarations from the federal court. So the facts with Mr. Rosado, slightly different, but not hugely dissimilar to Skene. Mr. Rosado was similar to Mr. Skene. He was effectively a labour hire employee working on mine sites. He was employed for more than 3.5 years, slightly under 4 years. Notably, he had 6 different employment contracts throughout that period, so 6 different assignments. So the contractual terms were all slightly different. He was not a fly-in, fly-out, but he was a drive-in, drive-out mine production operator working at a couple of mine sites. Again, he worked shift work and throughout that period worked either 7 on, 7 off or 5 on, 5 off. And the rosters were set by Glencore reasonably well in advance. And in one particular part of that period, the roster was set for the entire following year. So the 2 issues, as I said here, was, is Mr. Rosado a casual? And if he's not a casual, can we rely on that casual loading that we've paid to him for the last 3.5 years to set off or to recover the leave entitlements that he is now claiming? So the 2 issues here, they considered is Mr. Rosado a casual, and then they considered the double dipping issue. On that first issue, the full court, unsurprisingly, effectively adopted and followed the reasoning in the Skene proceedings, and again, enshrined or endorsed this firm advance commitment as being the thing that underpins what is a casual. Now, this notion of what is a firm advance commitment of work is very grey, and it's obviously not something that's going to be black and white all of the time. But what the court said here was a firm advance commitment is likely to not be there where someone is working irregular work patterns, there's uncertainty or discontinuity, the work is intermittent, it's unpredictable, and again, the bottom couple are important as well, where the employee can choose to accept or reject shifts, and where shifts are only offered in response to specific demands. So that is, for example, you ring up John and say, John, we've just had an order come in, so are you able to come in tomorrow and help out? And you can obviously contrast that with the Skene and Rosado circumstances where rosters were being set well in advance. In respect of Mr. Rosado, there's a discussion in the court decision about whether you answer this question solely based on what is in the employment contract or whether you consider post-contractual conduct. The court didn't need to decide that issue because they ultimately said, well, we can make the decision based on the terms of the contract anyway. And they went through the 6 different contracts, and they're all obviously a little bit different, but in a general sense, the contracts provided for, the first contract said, well, we expect that you'll work for 6 months with the possibility for further work. And it was expressed as a guide, but it obviously contemplated 6 months plus of work. The contracts also were very much couched on, the standard working arrangement will be 38 hours per week. Again, it was expressed as a guide, but it represents evidence of what the parties were planning. And again, those hours were pre-programmed in advance and fixed by a roster. The other thing that's important here was that Mr. Rosado, it was implied that Mr. Rosado was effectively required to work when he was rostered. So he didn't have a total freedom to reject shifts. And the specific circumstances here was that the contract said you are free to refuse a shift, but where you refuse a shift, you will become responsible for covering the costs of your accommodation and meals. Because of course, if you're going to come out and drive in for a 7-day roster swing and we put you up in accommodation and we feed you, you can't then sit there for 7 days and decide not to work and have a little bit of a holiday. So there was an expectation that when you are rostered on and you come out and we give you accommodation, you're obviously going to work. One of the observations in the judgment here was the very fact that the work Mr. Rosado was to perform was not to be performed. Sorry, bear with me one sec. I'll let you read that because I can't actually read the quote because of the way my screen's set up. So obviously what was really critical here was this idea that the roster was set long in advance as opposed to probably more standard casual arrangements. And I think if you just look at the facts of both Skene and Rosado, for most businesses out there employing casuals, you probably can distinguish yourselves from these to some extent. That is, you're not rostering someone a year in advance. So in relation to that first issue, they found, like Mr. Skene, that Mr. Rosado was not a casual because there was a firm advance commitment for him to perform work pursuant to an agreed pattern. So that now, we've now got the Skene decision and the Rosado decision, both of which are, and Rosado really doubled down on Skene, both of those very significant, full court, federal court decisions saying this is what the definition of casual employee is in the Fair Work Act and in the NES. If we turn to the second issue, and this issue wasn't completely considered in Skene, so Rosado really was focusing on, from a lawyer perspective, from our perspective, we heard the court's decision in Skene on whether or not he was a casual, but what was really critical for this one was let's unpack these arguments around set-off and double dipping. So WorkPac argued 4 separate grounds as to why they should be able to rely on the casual loading to set off or to recover the leave entitlements claimed. And I'll just make one other comment for Rosado. Skene focused on annual leave, on termination. Rosado was not limited to annual leave. The Rosado case was about annual leave, personal carers leave, and compassionate leave, because they all are couched in the same way in the Fair Work Act, which is casuals don't get it. But in this particular case, Mr. Rosado was sick at some point during his employment and also took compassionate leave. So he wasn't just claiming annual leave. The 4 grounds argued by WorkPac, and these are very technical, complex legal arguments, and the judgments are long and complex. The 3 judges of the federal court issued separate decisions, so there's not one joint decision. But the first was relying on common law set-off. So that is, we've paid you the amount in satisfaction of your entitlements, and we can rely on the casual loading to set off any claim that you might have for leave entitlements. The second and third were around restitutionary principles, and these are common law, equitable notions that have been enshrined in our legal system. They're not found in any legislation. But the argument was that there was either the loading was paid by mistake, or there was a lack of contractual consideration, and that's quite complex, and I won't go into that. But the argument was that we have mistakenly paid the casual loading. It's now unfair for Mr. Rosado to double dip. The notion of unjust enrichment, which is again an equitable doctrine, the principle effectively is if a party does something by mistake and one party is unjustly enriched, then the court has the ability to offer restitution to resolve the issue. And then the last one was that following Skene and WorkPac, the federal government issued a regulation which was purporting to try and provide some protection for these double dipping claims. And so they relied on that regulation. So all of those arguments were rejected by the federal court, and they effectively found that, and I'll explain why, and I might do that by reference to each of them. So in relation to the common law set-off principles, the court found that in order to rely on a set-off, there needs to be a close correlation between the payment that was made and what you're trying to set off. So, and some of this turned on the specific language. So the loading was paid in lieu of any entitlement to leave. And the court looked at the dictionary definition of what does in lieu mean, and they said, well, it means instead of. So the casual loading was paid instead of leave entitlements. So because the purpose of the payment was different, you can't rely on a payment made for one purpose to satisfy an obligation in relation to a second purpose. So reasonably technical. The second issue with set-off is around the timing of the payment. And what the court said was the loading was paid from day one. You were paid 25% for each hour worked. But if you think about annual leave and sick leave and compassionate leave as an example, the obligation to make the payment and the entitlement to be paid annual leave doesn't arise until you take annual leave. And so there was a disconnect in terms of the timing where the loading was not necessarily paid at the same time that the leave entitlement crystallised. So for those two reasons, the idea of set-off was not able to be used in this particular matter. And those principles obviously have wide ramifications for all employees and the nature of how people are paid. In terms of mistake, the court in simple terms effectively said, well, there was no mistake. WorkPac assumed the risk by paying a particular way. You made that conscious choice. You assumed the risk of what you were doing, and so therefore you're unable to rely on restitutionary principles. The last one, again, reasonably technical in terms of the court's decision on it. The court found with the regulation, and it turned on a few words in the regulation. The regulation effectively said that you can rely on the regulation to prevent double dipping where a claim is made for a payment in lieu of a leave entitlement. And the court said here, well, Mr. Rosado is not claiming a payment in lieu of the leave entitlement. He is claiming the leave entitlement. So they effectively overlooked the regulation or put that aside because the regulation talked about claiming a payment in lieu of something. And they said, well, he's not doing that, he's claiming the payment. So again, reasonably technical in terms of the court's decision of it. So where does that complex state of affairs leave us? There's a good chance that Rosado or WorkPac will appeal the Rosado decision to the High Court. It's obviously a matter of great significance, so there's every possibility that the matter will proceed to the High Court. Failing that, there has been some media reports and some discussion by the Minister for IR, Christian Porter, around working with the unions to look at what kind of legislative fix might be available. The obvious one might be to amend the Fair Work Act to put in place a definition of what is a casual. There might be some complexities around, so whilst a legislative fix might fix the problem moving forward, there might be some complexities around trying to fix the problem going back, because the court's decision in both Skene and Rosado was, the court was saying, this is what the law is. This is what the Fair Work Act means, and the Fair Work Act has meant this since 2010. So the effect of the decision is to give it retrospective operation because they're just interpreting the law as it has been since 2010. So the exposure, I guess, to businesses is that where you have been doing something similar to WorkPac and misclassifying people as casuals, there is some exposure that employees could claim back pay for up to 6 years going backwards. There's some complexity with fixing that in terms of a legislative fix. And there's complex constitutional reasons why that may be difficult. So we'll have to wait and see whether there will be a legislative fix, firstly, and secondly, if there is, whether it only kind of provides clarity going forward or whether it can also remedy things in the past. We'll most likely see the class actions that are on foot continuing and potential further class actions, given that the court has now made it very clear who is a casual and who's not, and what the position is around the setting off the casual loading. And more practically for businesses, obviously we're going to have to wait and see whether there's a High Court appeal. We're going to have to wait and see whether there's a legislative fix. What types of things businesses might be able to do in the interim? Well, the risk really is where you have casuals working for lengthy periods of time, working regularly and systematically, and where there is this firm advanced commitment of work. Where you have casuals working and would effectively meet the court's definition of a permanent employee, the risk is that the business is exposed to claims for leave entitlements, and there's certainly no guarantee, and in fact it will be very difficult to rely on the fact that you've paid a 25% loading to cover off those claims. So that's the risk. Moving forward, businesses should very carefully consider how they engage casuals. It may be sensible to do an audit of your existing casual workforce to consider where there might be some exposure and some risks. The obvious thing to do for casuals who are working regularly and systematically, if it's practical, is to offer casual conversion. Where you convert someone to permanent, you stop paying the loading and you start accruing leave entitlements. That will effectively cease the risk from that day onwards. Now, it's unlikely to provide any protection going backwards, but you can potentially resolve the issue moving forward. In terms of redrafting employment contracts, the Rosado matter very much focused on the terms of the contract, and there's things that you can do in terms of the drafting of your employment contracts to improve your position. But the bar has really been set pretty high by the federal court. One of the judges in his decision said, you effectively need to have a debt recovery facility. So whether it be in the employment contract or a side agreement, having something that says, we are paying you the loading. If you are found to not be a casual, you agree that the loading paid to you immediately becomes a debt payable to us, and there's some debt agreement. So very kind of complex arrangements. And from a HR perspective, you'd have to wonder how a change like that could be implemented into an employment contract and how you communicate that to the workforce. And the other obvious concern might be, well, the second you start having discussions about these things, do you open up a greater likelihood of claims being advanced by existing employees? So there are some things that you'll be able to do to your employment contracts. One of them, for example, is that the court found, because the loading was described as being paid in lieu of leave entitlements, and they said, well, hang on, you can't use that loading to cover the leave entitlements because you've expressly stated that you're paying the loading instead of leave. And so you can imagine, if the loading is described rather than in lieu of leave entitlements, the loading could be described as being in compensation for leave entitlements. That may improve the position, but the court has hardly set out a roadmap for what you need to put into your employment contract. The decision's something like 185 pages, and there's 3 judges, 3 separate judgments. So lawyers are still unpacking the complexities around restitutionary principles, etc. And so there will be some tweaks that can be made, but will they provide you with total assurance? Very unlikely. For businesses that have highly casualised workforces, I mean, I can obviously give you some general guidance today, but I'd be recommending that businesses seek specific legal advice that's tailored to their circumstances. One issue around casual conversion, because I think since the scheme decision in 2018, our firm certainly made some changes to clients' employment contracts to cover off as much as possible this double dipping issue. By way of example, we were drafting contracts to say that the loading is being paid to you on the mutual belief and understanding that you are a casual at law, and if this turns out not to be the case, then we have the right to recover the amount and to set it off. So there was some protection in terms of the drafting that could be made following scheme, but we're going to have to make some further tweaks because Rosado has changed again the landscape in terms of what might work and what won't work in terms of trying to recover the casual loading. The other issue that businesses were doing, or the other thing that businesses were doing following scheme, was offering casual conversion, because that's obviously one of the key, one of the likely answers here is to convert casuals to permanent. one of the practical difficulties there is where casuals say, well, no, I'm not keen to convert to permanent. I like being a casual, and they've declined requests. And following Skene, our advice to clients was, well, provided that's documented and you have the employee sign off saying it's been offered, they don't want it, they acknowledge that they will continue to receive the loading, they acknowledge that they're not entitled to leave entitlements, etc., etc. That offered some protection, but it's unlikely, following Rosado, to be particularly effective, because the fact that an employee doesn't wish to be converted is really neither here nor there. What the court has said is, this is the definition of casual. You're either a casual or you're not. If the person is at law a permanent employee, but you've continued to engage them as a casual because they don't wish to convert, the fact that they don't wish to convert is not necessarily going to give you that protection. So, Amy, that was probably all I wanted to say, and I'll hand over to you, I think, to take as many questions as we can in the time that we have remaining.
Thanks for that, Kyle. Yeah, certainly a very complex and uncertain situation. We did have a lot of questions about that issue of casual conversion and the employees themselves not wanting to convert. So I guess there's probably not a lot more advice you can give on that one at this stage. There's people who kind of between a rock and a hard place with it. Is that the case?
I think that's right. I mean, you'd need to consider on a case-by-case basis, is the person a casual at law, or are they not a casual? And if they are working effectively as a permanent employee within the court's definition, then there is risk if you continue engaging them as a casual. And so the fact that they might wish to continue to work as a casual and receive the loading, there's still exposure to the business, because ultimately the court, if it was challenged, would say, well, they're not a casual, you've mistakenly paid them the loading, you should have paid them leave entitlements instead, and you can't automatically rely on the fact that you've paid the loading. So it does raise some real issues as to, it's not so much, it shouldn't necessarily be so much of a choice for the employee as to which category of worker they wish to be, but the business has to probably be a little bit more proactive and say, well, you're actually now a permanent, you're working as a permanent, so we will offer you permanent employment. It does raise some practical issues where if you offer them permanent employment and they decline, do you cease rostering them on? Do you start recruiting externally for a permanent employee? And that is obviously quite a complex situation. And I think if you're in those situations, you should obtain some legal advice as to how you properly structure the workforce, because it is difficult. I think the reality is, the short answer is, if you've got people wanting to stay as a casual, but they're not working irregularly and unpredictably, then the business and the employer is taking on that exposure moving forward. And so businesses will need to have a conversation with the employees and work out an arrangement.
I've got a question from somebody who says they've got a long-term casual, someone who's been with them since 2017, but their hours are quite irregular. They could be anything from 5 to 20 hours a week. Are they still in a position where they may be liable under this ruling?
So that's kind of the $64,000 question. Is there's still significant grey area in the idea of who is a casual and who's not. I think Mr. Skene and Mr. Rosado were probably at one extreme in terms of the way in which they worked and they were rostered. And then you'll have the other extreme where the working pattern is totally unpredictable and all over the place. And then you've got a huge middle ground where it's somewhere between the two, where there might be a degree of predictability or a degree of kind of regularity to it, but it's not totally fixed. And so that's that really difficult area where a call will need to be made as to whether or not they are casual or they're permanent. And one of the difficulties is, and I alluded to this at the start of the session, talking about the fact that modern awards define who a casual is in a particular way. Modern awards equally define who are permanent employees, so that modern awards will have definitions of part-time employees, for example, and most of the awards will define a part-time employee as someone who works less than 38 hours on a reasonably predictable basis. And the question is, well, what does that mean? And there may in fact be a gap if you think about the three categories of work. Full-time, that's pretty clear. Part-time, the modern award defines it in the way that I've just described. And then casual, and we have the federal court telling us how casual is defined. To my mind, there may be a gap between casual and, for example, part-time, where they may not be working reasonably predictable hours, but equally they may not be working totally unpredictably. And so the question that we're going to have to wait and see the answer is, will there be changes to the modern award definitions of both casual and potentially permanent part-time to bring some consistency with the full court and the federal court's decision? Because, as I said, the modern awards to this day continue to define a casual employee, for the most part, as someone who's engaged and paid as such. And that's somewhat unhelpful, where that's totally inconsistent with what the federal court has said. So will the Fair Work Commission vary the modern awards to reflect the federal court decision? One would think that should naturally follow, but we'll have to wait and see. And so the scenario that you put is kind of in that grey area where it probably is still casual, but if it goes on for 3 or 4 years and the person develops a reasonable expectation of ongoing work, then it gets into a very complex, kind of risky area.
Just going on from that, a couple of people have asked that if you have a casual employee who either requests or accepts an offer to become permanent, and you begin to pay them leave, do you now need to pay them? Does that leave need to go back to when they first started?
Well, the short answer is leave would commence accruing from the date on which they cease to be a casual, pursuant to the federal court's definition. And that will be a very difficult date to assess because, of course, the arrangement will fluctuate where someone will start truly as a casual, working very unpredictably. And then it will morph sometimes over a year or two into a much more stable roster pattern. And the question will be, well, at what point did it change from being a casual to a permanent? And a business might be able to say, well, to a particular employee, you are now working as a permanent and you've been working as a permanent from X date. But there's no guarantee that the employee will agree with that date. And the employee may say, well, I disagree. I think I morphed into a permanent much earlier than that. So, as I said, there's no easy answers in terms of how this practically is applied. But I think conversion is the obvious solution in terms of managing the risk going forward. But it of itself in that process kind of also triggers potential risk looking back.
Going on again from that, we've got a question that if a casual employee is offered and accepts permanent part-time employment and drops their casual loading, can there be a flexibility clause in their contract stating that they agree to their hours being changed from time to time to retain the flexible nature of the role?
The short answer is probably not. It will depend on the modern award that applies. It might be slightly more flexible if there's no modern award that applies to the employee. But for the most part, the modern awards define a part-time employee as someone who works less than 38 hours per week and has reasonably predictable patterns of work. And so if you convert someone to permanent part-time, for example, and you cease paying the loading and you start accruing and paying leave entitlements, you run the risk that you would be breaching the modern award if you then require that employee to work in a manner that is inconsistent with the definition of part-time employment in the modern awards. And the other clause that's in quite a few modern awards effectively states that at the commencement of employment, the employer and a part-time employee must agree on the number of hours worked per week, the days of work per week, and the starting and finishing times. And it then states that once you reach that agreement on a fixed pattern of work, it can only be varied by written agreement. So many of the modern awards require you, even though it talks about the nature of part-time employment as being reasonably predictable hours, the clause then effectively requires you to fix a pattern of work with some prescription, saying starting and finishing times. And then it only allows you to change that if the employee agrees and you record that agreement in writing. So you may be able to work the part-time employee slightly more flexibly, but depending on the award that applies, that might require you to effectively seek the employee's agreement on a week-by-week basis. So the ability to do that will likely be qualified and limited by the modern awards.
Someone's asked about the definition of predictable periods of working time, which I guess you've already said is a bit hard to put your finger on. They've given the example of a roster that's set a month in advance. Would that qualify under your understanding as a predictable period of working time?
Yeah, I mean, the difficulty is, like lots of things in employment law, is there's no hard and fast rules. It's like the old myth that you can't sack someone unless you give them 3 written warnings. The law doesn't prescribe any time frame for these things. So I certainly would not be advising that businesses roster casual employees for more than a month in advance, because I think that's significantly risky, because it's effectively evidence that there's this commitment for work a month in advance. And that probably sits inconsistently with the notion of being fluctuating based on demand of the business. If you're able to roster a casual a month in advance, prima facie, you would expect that you've got a fair degree of stability in the working arrangement, and the demand for that person's labour is fairly steady. So I'd be much more comfortable if employers and businesses were rostering casuals on a week-to-week basis. A fortnight-to-fortnight basis is obviously not as good as a week. Anything more than a fortnight, I'm uncomfortable with a month, because I think that of itself starts to suggest that there's predictability and there's some certainty. And if I was a casual employee being rostered a month in advance for 3, 4, 5, 6, 7 months, you can start to see there's this reasonable expectation of a commitment of providing me work. So I wouldn't be comfortable with a month in terms of the roster cycle. I don't think that's ideal.
Okay. You mentioned earlier that converting someone from a casual obviously covers you going forward, but not necessarily retrospectively. Do you think legislation will be able to address that retrospective aspect? And going to that question, I've got a question from the audience about whether the back pay option is kind of more likely than just amending awards for the future.
I think it's conceivable that they can amend the legislation to address the retrospective operation of the decisions. There's some constitutional problems with acquisition of property. So you can't necessarily say, well, you've been paid the casual loading, it's in your possession, we now need you to pay it back. So there's some complexities to that, but one legislative fix, for example, may be in the National Employment Standards, where it says employees are entitled to 4 weeks of annual leave per year of service. You could have something that says subject to where an employee has an entitlement to annual leave, or employees are not entitled to annual leave in circumstances where, or in respect of a period for which a casual loading was paid. So I think it can be drafted in such a way to say that this is the entitlement. But again, presumably, unless the Parliament give that retrospective operation, it's likely to only apply moving forward. So it's very, very complex.
You mentioned also that the Rosado decision went a bit further in covering things like annual leave, carers leave and compassionate leave. Could something like maternity, or for that matter paternity leave, also come into play here?
I think parental leave is probably a little bit different. Firstly, because just in terms of the financial component for businesses, the NES only provides for 12 months unpaid parental leave. So it's unlikely to kind of have any financial impact. For example, if Mr. Skeen said, well, I was entitled to take 12 months parental leave, but they didn't let me, it's hard to see, because it's not a financial benefit, it's hard to see that would have a huge impact. And I'm just trying to think through the NES. There's also community service leave, but again, that would be unpaid. There's jury service leave, so that might be a potential financial entitlement there, but again, that would come up fairly rarely. But it's those paid leave entitlements, annual leave, personal carers leave, and compassionate leave, where there would be an underpayment.
All right. Casuals often have more than one employer, so would it dilute the predictability test if they were, say, working on weekends for one employer and weekdays for another?
Look, I think it's certainly helpful. It would change the landscape compared to, for example, Skene or Rosato. If an employee has multiple employers and is working casually for two or more businesses, it's likely to be a relevant factor. But it's not determinative, because you'd have to look at the pattern of work. And for example, you could have a scenario where a casual employee says to one employer, I'm available to work for you between 9 to 5, Monday to Friday, but I'm not available to work on the weekends because I have a second casual engagement where I work at the pub on Saturday and Sunday nights. The fact that there's that second employment on the weekend does not necessarily mean that the first employment cannot be permanent. Because again, if that employer was rostering, let's say, a month in advance, 9 to 5, Monday to Friday, 38 hours a week, it would be difficult to see how a court would find that is still casual.
I've also had a couple of questions around employees who are getting JobKeeper payments or who are registered for JobKeeper, and whether or not by registering a casual for JobKeeper, whether the business is exposing itself to a claim for these types of leave entitlements.
Yeah, I mean, that's a really interesting question, because as I said at the start, the Fair Work Act does not define who is a casual. But the Act has a couple of other references in it. One is to long-term casuals, and the other is to casuals working regularly and systematically. And the regular and systematic casual formulation in the Act is relevant to eligibility to bring an unfair dismissal claim. So if you just think about that, the fact that the Fair Work Act talks about regular and systematic casuals is a suggestion that the Parliament were contemplating that casuals could legitimately work as regular and systematic casuals and still be casuals. However, that kind of now sits uncomfortably with the Rosato decision, saying, well, arguably, if you're a regular and systematic casual, you may well be found not to be a casual. So again, there's that disconnect. Likewise with JobKeeper, it refers to the threshold for JobKeeper eligibility is you've worked there for 12, if you're a casual, you've worked there for 12 months and you've worked regularly and systematically. And I think if you're an employer and you've claimed for a casual employee, you've effectively made a declaration that that employee has worked for you for 12 months on a regular and systematic basis. That of itself may be getting you into that grey area of, okay, well, if they're working for 12 months and they're regular and systematic, there's probably some risk that they're not in fact a casual, despite the fact that the Fair Work Act talks about regular and systematic as being something that casuals can do. So it's just incredibly complex. I think there needs to be some legislative fix or some consideration by the High Court, because it's just difficult to reconcile the Federal Court's decision with what's in modern awards and what's also in the NES. So, yeah, I mean, the short answer to that question, is I don't think anything huge turns on the fact that you've claimed for a casual. It's purely evidence that you've determined that they're regular and systematic. That doesn't mean that they meet the Federal Court decision, but you're probably getting close to that territory.
What about situations where, and close to home, for example, like someone who might go up to the vineyards and help with the grape harvest over a period of 4 to 6 weeks, where, logically at the start of that, they're going to be told, well, we're going to need you, 5 days for the next 6 weeks, but then it's gone. Would that, the predictability test, would that be a grey area also, or things like that where you get groups of work, and it might be Ausgrid doing some work and pulling in contractors to help fix some wires over a 6 week or a 10 week period or whatever it is. Is there any issues with that sort of arrangement?
Oh, look, I don't think you can rule it out entirely that it's a completely fine arrangement. The fact that it might only go for 6 weeks is only one relevant factor that would be taken into account. I think businesses where there's a short-term arrangement, but it's still effectively working 38 hours a week for 6 weeks, consideration should probably be given to whether you could engage the person as a fixed-term employee. So they would be, let's say, permanent full-time on 38 hours a week, but for a fixed-term period. That may be a safer way of engaging them. But I mean, you'd have to look at that specific arrangement and say, okay, well, if you're working in the vineyards for 6 weeks, are you working 10 hours a day every day between 8 and 6? Or is it very volatile depending on the work that needs to be done on a particular day? So you'd have to kind of look at all the factors and weigh it up. And I mean, where we're at now with casuals is not dissimilar. Like, it's a good analogy to compare it to the test for whether someone's an employee or an independent contractor. The law is somewhat unclear because the court, for determining whether you're an employee or an independent contractor, applies this multifactorial test where they say, well, no one factor is determinative. We need to look at everything, weigh it all up, and then form a view. And it's very much a kind of iterative process where it's not clear cut. And we're now in a situation where working out whether someone's a casual or not is not, very similar to that. So, yeah, I wouldn't be ruling it out that it's completely fine.
Okay, probably just got time for one more. We've got a question about whether this matter is on the agenda of the current union, business and government dialogue heralded by the Prime Minister this week, and how Hunter Business Chamber and ABLA can contribute to that outcome. So I think from our perspective, I can confirm that the Chamber, through our partner organisation, Business New South Wales, would certainly be making submissions on this matter. Might throw to you, Kyle, to say what ABLA's involvement might be.
Yeah, so the answer is yes. This will be on the agenda in terms of the recent announcement where I think Scott Morrison at the National Press Club address agreed to effectively park or get rid of the union busting legislation, if I can describe it in that way, as a show of good faith to work with the unions to try and come up with some constructive industrial relations reform. This will very much be a topic on the agenda, and I think the federal, coalition government have effectively flagged that it's an issue that needs to be resolved. The Business New South Wales and ABLA will be involved in that process. I suspect what will happen is that the Australian Chamber, so the body of all the state chambers, will have a seat at that table and will be making submissions and advancing reform proposals. The other thing that might happen is we might see some claims to varied modern awards around the definition of casual or the definition of part-time. So the Business New South Wales will certainly be involved, and ABLA will be advising them as to how the situation might be able to be addressed as quickly as possible.
All right, well, thanks, Kyle. We've run out of time, and for mine, that hour has gone extremely quickly. This is obviously a very complex and inclined situation where, as you said, there's no one answer, and it sounds like the relief or the answers to some of these questions is going to be through an iterative process that's going to be tested and retested and tested again and retested again. And so it sounds like it could be ongoing. And I know that's difficult for business because we always like things to be in black and white, so we've got certainty about how you might employ people and take them on. But it sounds like this one might go on for a while. So it's been very insightful, and I'd ask everyone to join me in virtually thanking Kyle because it's the information that you've imparted to us today, Kyle. There's a lot more to come, but you've obviously waded through a hell of a lot of stuff, and we really do thank you for taking time out of your busy diary for being with us today. So thank you.
No worries. Thanks, Bob. A pleasure.
Just before I close, ladies and gentlemen, if you do have questions, of course, and I'm sure you have that weren't answered today, for those that are your members, You do have entitlements on the Business New South Wales Workplace Advice Line on 132959. That's up in it should be up on your screen shortly if it's not there now. And also Australian Business Lawyers and Advisors, of course. And as I said, there is an office here represented here in Newcastle, which Kyle is the Associate Director and leader of that team. I'm sure they'll be willing to assist where they can as well. So I refer those to you, and we'll certainly try and keep members up to date with progress on this issue as it goes forward. Just before I close as well, just a reminder that our Survive and Thrive series, next week we've got Tanya Constable, the CEO of the Minerals Council of Australia with us. So that's next Wednesday, and that's going to be sponsored by Strata Worldwide. So for anyone in the mining industry, that's going to be particularly interesting presentation from Tanya. Thanks again for everyone for being part of this session today. Thanks to Amy and Kyle again. Thanks for Jack for helping me out of screen here, but I can assure you my technical capabilities are extremely limited, so I'm thankful for the team around me to help get through these things on a regular basis. Have a good day, have a good weekend, everybody. Stay safe, and good luck after the 1st of June with getting out there amongst it, and keep in touch with what activities we're up to, and we'll keep you informed of progress of relief that might happen as restrictions are slowly eased.